Ladies and gentlemen, we just got some breaking news in the Ripple versus SEC lawsuit. And even though the XRP price is not pumping like crazy, this news alone pumped the price by 4%, and I honestly think it can still do a significant amount more to the price because it's that big a deal. So if you've not done it yet, make sure you press that like button right now to lock in your support. And guys, I'm excited! You might be looking at this XRP price thinking, why is it up 4%? 4% is a significant amount if Bitcoin is down. If Bitcoin were to be up today, I honestly believe XRP would have also gained a significant amount more. But you can see this is exactly the point where the news came out. The price went up roughly 8%, something like that, and right now it's fallen down a little bit again. But the news is as follows. It came out 5 hours ago because I was asleep. And actually, guys, I did wake up, but for some reason, sometimes you have it, you fall back asleep. Judge Torres has denied the SEC's motion to file an interlocutory appeal. Whoa! So this has two sides. From one end, it's extremely bullish because this once more shows, screw you SEC, you're not important enough, don't try to come in with your rules and tell us what to do. The judge saw right through it. On the opposite side, it's actually not that nice. We did actually have the idea that if the judge allows for it, she can just slam it down so the SEC won't have any power in the future. But I suppose the arguments the SEC made for why this is so relevant to do now were not strong enough, which again shows also their usual BS stance. Anyway, let's quickly read through just this part. Plaintiffs, the SEC, brings this action against defendants Ripple Labs and two of its senior leaders, Brad Garlinghouse and Chris Larsen, alleging that the defendants engaged in the unlawful offer and sale of securities in violation of Section 5. The SEC also alleges that Larsen and Garlinghouse aided and abetted Ripple's Section 5. Oh, microphone cut out. Hopefully we're good. Section 5 violations. The court granted in part and denied in part the parties' cross motions for summary judgment, which again was that Ripple selling XRP over exchanges was completely fine, not security offerings, but Ripple selling XRP direct to some people, some companies, that was a violation. And the SEC wanted to turn everything around, say, hey, Ripple, if you gave XRP to developers, if you sold XRP over exchanges, we also want those to be reconsidered. And the judge now said, nah. To be a little bit more specific, they had institutional sales under written contracts, which received $730 million, programmatic sales on digital assets via exchanges, which again was about $750 million, and other distributions under written contracts, in which it recorded $610 million, in considered other than cash. And of course, they're also saying that Brad and Chris Larsen sold themselves. Under Section 5, it's unlawful for any person to directly or indirectly to offer, to buy or purchase or sell a security unless a registration, yada, yada, yada. At summary judgment, defendants did not dispute that they had offered and sold XRP through interstate commerce, and they did not registered those offers or sales. And more of why the SEC thinks that this should all be granted. The SEC also requests that the court stay on remedies litigation and any pretrial proceedings while its interlocutory certification request and any appeal are pending. This basically meant they wanted to stop the entire lawsuit for right now, and again, get back on these programmatic and other distributions of XRP to also get those ruled as basically illegal or unregistered. Anyway, and so the judge now goes into the offense mode against the SEC for the most part. As an example here, under this rule, a question of law must refer to a pure question of law that the reviewing court could decide quickly and cleanly without having to study the record. Here, the SEC has not presented a pure question of law that could be decided quickly and cleanly without having to study the record. To the contrary, the court examined the totality of circumstances surrounding defendants' different transactions and schemes involving the sale and distribution of XRP, and ultimately found that the institutional sales were sales of securities, but the programmatic sales and other distributions were not. In doing so, the court studied an extensive, heavily disputed factual record and detailed expert reports. Point being here, it's not a quick little, hey, you might have done something wrong right there. It's a, let's do everything over again, even though you've studied 1,600 purported facts, many which are disputed by defendants, and over 900 exhibits cited, which basically means, again, the judge has solidified her ruling, and she's done it now again in this document by saying, hey, whenever I came to this conclusion, there was no discussion possible anymore, as I've literally gone over thousands of different things to come to this conclusion, and the SEC does not argue that the court applied the wrong legal standard in deciding the cross motions for summary judgment, so that's also not what the SEC is saying. In fact, the court specifically rejected Ripple's essential ingredients legal test and applied the SEC's legal standard. Rather, the core of the SEC's argument is that the court improperly applied the Howey test to the facts in the undisputed record. As the SEC repeatedly argued, Howey must be applied to the facts and circumstances at hand. And under these circumstances, such questions do not present issues of pure law, and therefore are not appropriate for interlocutory appeal. The court also rejects the SEC's argument that the questions presented are controlling questions of law because the certified issues have precedential value for a large number of cases, which again is kind of difficult for the SEC to prove. This point is basically that the SEC says, hey, whatever is decided here is very important for other cases. And the court basically says, well, we went for a direct application of Howey in your test, whatever you wanted, and that's all bound to unique facts and circumstances of specifically this case. The other enforcement actions cited by the SEC involve different digital assets in different companies, which again, they literally before stated don't really matter at all because it must be applied to the facts and circumstances specifically at hand. It will depend on the facts and circumstances, including the economic realities of the transaction. So in their, argument here, they're misconstruing the court's holdings. For example, the SEC seeks to appeal the question, can an issuer's offer and sales on crypto asset trading platforms create a reasonable expectation of profit based on the efforts of others? But the court did not hold that offers and sales on digital asset exchanges cannot create a reasonable expectation of profits based on the efforts of others. The court held that based on the totality of these specific circumstances, including an examination of facts, circumstances, and economic realities of the transactions, Ripple's programmatic sales in this specific case could not lead investors to reasonably expect profits from Ripple's efforts. So again, the judge noticed the SEC is trying to take this out of the box, and a couple of points were made, which again led her to this conclusion, that they were a blind bid and ask. They were only like less than 1% of all the trading volume. Ripple did not really make any promises at all, and people didn't really know who they were buying XRP from, and Ripple did not know who they were selling it to. A lot of people, and this is very much true, like anybody that I ever helped buy any crypto, they don't know who Ripple is. There were no contracts involved. The SEC failed to prove evidence that Ripple tried to promote it to the general public. Not necessarily institutions, as those were agreed upon by the judge that the SEC was kind of right. But for the public, never. And the SEC failed to provide evidence that objective, reasonable, programmatic buyers understood that statements made by Larson, Ripple chief cryptographer David Schwartz, Garlinghouse, and others were representations of Ripple and its efforts, and the SEC failed to provide evidence that an objective, reasonable, programmatic buyer could parse through the multiple documents and statements, sometimes inconsistent, across many social media platforms and news sites from a variety of Ripple speakers over an extended 8-year period to discern Ripple's marketing campaign and public statements connecting XRP's price to its own efforts. That was a mouthful, but you understand. And again, the point here being is that this court has basically gone over everything really specifically for this digital asset, not a general rule of thumb, right? Not something that can be extrapolated to every other case. Other cases could copy the same sort of analysis and might draw to the same conclusion, but it's for this specific asset and circumstance. So the SEC has no right to turn this around and say it's important for other cases the way they describe it to be. Again, there's some different things they have to prove, right? Another one is substantial ground for difference of opinion. And again, in this case here, that doesn't really make sense. She literally says, not so. And it's kind of funny. The Terraform court was required, as it must, at the motion to dismiss stage, to accept as true all well-pleaded allegations and to draw all reasonable inferences in the SEC's favor. So again, that was necessary for the motion to dismiss. If you want to get a motion to dismiss out the way or approved, you have to basically say, hey, even if all this is true, it still really wouldn't do anything. If that's the case, then throw it out, which is very hard to do. The Terraform court then presumed that the defendant's representations would have reached individuals who purchased their crypto assets on secondary markets, and simply put, secondary market purchasers had every bit of good reason to believe that the defendants would take their capital contributions and use it to generate profits on their behalf. Point being here, well, in the Terra case, which the SEC now is using as an argument, I remember when they did that, what they were doing in Terra was basically stating, if everything you're saying is true, then this. The thing is, it's not proven that every single thing is true. It's just said, if everything is true, then this. So whatever's happening in that case here is not too relevant for this specific part. Because again, it's about very specific circumstances and situations. And the question about programmatic sales over exchanges on the secondary market to retail investors was not actually put up, or at least not turned upon. Rather, the court concluded that based on the totality of circumstances that an objective, reasonable programmatic buyer was not led to expect profits from the efforts of Ripple. Unlike in Terraform, the reasonable programmatic buyer would not believe that sales for purchaser of all XRP would be fed back into Ripple, yada yada yada. So the Terraform case is different, the judge notes upon that. And again, a lot of the Ripple promotional pieces were only sent to institutional buyers and not like the normal folk. And so again, the court denies this argument that there's a substantial ground for difference of opinion about the court's holdings as to other distributions, because again, they can't say there's a different legal standard that was applied. And for what I just stated, the court just denies the SEC's attempts here, because again, they've gone through every single piece of this really thoroughly. And then our last point, or at least one of the last points, materially advance the ultimate termination of the litigation. In determining whether certification will materially advance the ultimate termination of this litigation, this point just means that this is helpful in getting this lawsuit resolved in a better or quicker way. Courts must consider the institutional efficiency of both the district court and the appellate court. Here, the SEC fails to meet its burden to demonstrate that interlocutory appeal would materially advance the ultimate termination of this litigation. And again, the point there being that if stated as above, if the Second Circuit were to reverse the order and remand the case, the court would be in a position of considering many complicated legal and factual issues in the first instance, such as whether Ripple's programmatic sales satisfy Howey's second prong, that there exists a common enterprise, or defendant's fair notice defense as to the programmatic sales and other distributions, which right now was actually denied. Then any party that disagreed with the court's subsequent summary judgment order could move again for interlocutory appeal, because it's just a matter of interpretation at the end of the day now. Therefore, any interlocutory appeal would instead likely prolong the action, as it would be subject to multiple bites at the apple for appellate review, right? Because it's like, if she goes over it again, it's like making an initial conclusion where the doubt would still, theoretically speaking, be there, as it's a different interpretation. But if she also came to the first interpretation and now the second one, it's like, since it's such a very specific part, which one is right then, right? And with so much to still continue on, right? So many questions to still be asked, etc., etc. Under these circumstances, litigation may be most expeditiously advanced by proceeding in the ordinary course to judgment. And sometimes my mic cuts out because of the setup I've got here. The cable management I've got is it's not too good, or rather it's good, but it's like hanging off. So sometimes the cable, if I bump my table, it just shakes a little bit and then the mic cuts out. I don't know. By the way, make sure you press that like button. Make sure you subscribe to the channel for every single time I post these videos. I try to do this as quickly as possible. I've just waken up. There might be still like, I might be looking tired still. I've just woken up, instantly get to the video, which is why my eyes are a little bit like this. Can you imagine waking up and having to read a lawsuit document of 14 pages? Yeah. I'm not even a lawyer, by the way. What in the world? The court is aware that the litigation may be extensive regardless of whether interlocutory appeal is granted. But here, the SEC has failed to meet its burden to show that such an appeal would actually really help the lawsuit go quicker. Now, that's the conclusion. That's the last page. For these reasons, the SEC's motion for certification of interlocutory appeal is denied, and the SEC's request for a stay is denied as moot. The clerk of court is directed to terminate the motion. Trial on this matter is set to begin April 23rd, 2024 at 9 a.m. The deadline set forth in the court's pretrial scheduling order remains in effect. Accordingly, December 4th, the parties shall submit any motions in limine, I'm not sure what that word is. Oppositions to any motions in limine shall be submitted by December 18th. By December 4th, the parties shall submit all required pretrial filings, including their proposed joint pretrial order, request to charge, verdict form, and voir dire questions in accordance with paragraphs VB, VC, and VD of the court's individual practices in civil cases. December 4th, the parties shall deliver to the court one copy of each documentary exhibit sought to be admitted, pre-marked, i.e. labeled with exhibit stickers, and assembled sequentially in a loose leaf binder or in separate manila folders labeled with the exhibit numbers, and placed in a suitable container for ready reference in accordance with paragraph VC of the court's individual practices in civil cases. And then all the way on April 16th, so about a week before the date, right? Counsel for all parties shall appear for a final pretrial conference in courtroom 15D, which is kind of interesting that they put this forward half a year before, that they scheduled this already. And prior to the final pretrial conference, counsel for both parties, along with the parties themselves, shall meet in person for at least 1 hour to discuss settlement of this matter. So again, they are going to be sitting down to discuss some sort of settlement instead of going to trial to, of course, expedite the process, get things done quicker. So ordered the judge in New York. Woo! That was a long one, but it's actually kind of a short document. We went over everything because I thought that might be the best way to go about this, right? Denied! The SEC was completely denied. Very, very nice. Yeah, I don't have that much more information to give to you except for the fact that this is pretty nice for XRP. All the lawyers are pretty excited. 𝗕𝗓𝗀𝗀𝗀 said the SEC's motion for intellectual property is denied, which means the case either goes on to April or goes away. And this order allowed the judge to explain parts of a ruling even better, making appeal that much harder for the SEC to win in the future. This is a disaster for the agency. I like how the judge here clarifies her holding, at the same time reminding the SEC that speculating in a commodity alone does not meet the test, but that you also must rely on the efforts of others, which the SEC failed to prove. 𝗕𝗘𝗪𝗏 saying the SEC should not even bother appealing. They keep embarrassing themselves with every loss against Ripple. And Jeremy says, who at the SEC wants to try this case against Галлinghouse and Larson? I wouldn't want to because, again, it's a very hard case. And perhaps, guys, perhaps, Gary Gensler just turned into such a villain because Jay Clayton gave him this case. What if that's actually what's going on? Gary Gensler was just sitting in his chair thinking, I'm going to become the chairman of the SEC. Happy as shit because he's really pro-crypto. But all of a sudden, all right, one of the most embarrassing cases is thrown in front of his face. And now he's like, you know what? Let me become the villain or something like that because he's just that distraught. He's just messed up in the brain now because he was throwing such a stupid case. So perhaps it's Jay Clayton who's to blame. And that's turned Gary Gensler into a crypto villain. I'm not so sure, but that seems to be the case. Anyway, guys, that was it for this quick crypto update. If you guys all enjoyed this video, make sure you press the like button and subscribe and put the notifications on if you want to be further notified for videos. Obviously, if you're just watching this one time, you don't need to subscribe, no need for notifications. But if you want to be kept up to date, it's very important you put those notifications on. But again, you decide for yourself. And the like button is just because you enjoyed the video. Yeah, that's it.